"Let me see your papers right now." Those 5 words landed in the air of Hayes Pharmacy like a slammed door. Customers froze mid-step. The fluorescent light seemed suddenly too bright against the crisp white of Dr. Vanessa Lynn Mitchell's coat. Behind the counter, the row of prescription bottles and the framed license on the wall, the quiet architecture of a trusted profession, became the setting for an encounter that would ripple far beyond that small, hot room. Vanessa didn't shout. She didn't plead. She set down the bottle she was holding, looked the officer in the eye, and asked the question anyone with a law degree or a measured understanding of rights would expect. Why? What am I suspected of? The officer's demand did not answer the question. Instead, it escalated. The scene was recorded from multiple angles. The officer's body-worn camera and the pharmacy's CCTV captured the same moments from different perspectives. Those recordings, later played for a jury, showed a sequence that the written record would summarize as an unlawful escalation. An officer pressing for identification without articulable suspicion, a plea to understand the basis for the stop met with an insistence to produce papers, the step across the counter into the restricted area where pharmacists work, the handcuffs, and the search of a purse that, among other things, contained the very documents that should have ended the encounter immediately, proof of U.S. citizenship and professional credentials. If you care about these stories, subscribe now. There are more like this one that show how recorded truth can reshape public accountability. Dr. Vanessa Lynn Mitchell is, in every factual sense that mattered in court, a professional. Born in Houston and practicing pharmacy for more than a decade, she'd spent years building trust with patients, supervising staff, and maintaining a calm, precise demeanor behind the counter. To customers, to colleagues, to the community she served, she was the person you wanted checking your prescriptions, a figure of competence and steadiness. To the officers in patrol cars that day, she was someone whose presence stopped them and triggered suspicion. One of those officers was Blake Morrison, whose conduct would later come under intense scrutiny. His partner that day, Rachel Brennan, would come to occupy a different place in the record. Reluctant, caught between loyalty to a colleague and the undeniable clarity of the camera footage. What happened at Hayes Pharmacy is straightforward to describe and complex to explain. On the mercy of a typical American summer day, the heat, the bell over the door, the conversation with a customer interrupted, a law enforcement interaction crossed the line from ordinary contact to a constitutional confrontation. The Fourth Amendment, which protects against unreasonable searches and seizures, requires police to have a particular level of factual justification before they can detain someone. At trial, that concept would be explained and unpacked by experts in terms anyone could understand. Reasonable suspicion means the officer must be able to point to specific and articulable facts supporting a belief that criminal activity may be afoot. Probable cause is a higher threshold, requiring a fair probability that evidence of a crime will be found or that a crime has been committed. What the footage showed, and what eventually animated civil litigation, was that none of the usual markers for an investigatory stop were present. Vanessa was behind the counter at her workplace. She was doing her job. There had been no call or reported emergency that matched the officer's sudden move. Morrison's demand for identification came across as a demand for papers absent the facts necessary to justify detainment. When Vanessa asked for the reason, she did not get a reason that met the legal standard the Constitution requires. The immediate outcome of that exchange was an arrest and a search. Vanessa was handcuffed, taken to the booking station, processed and released after hours. Criminal charges were filed initially. Obstruction and failure to provide identification according to the police report, but they would not stick. Prosecutors later dismissed the charges after reviewing the evidence, a move that would underscore the mismatch between the initial police action and the legal thresholds that constrain it. The dismissal did not erase the experience. It did not restore the hours of indignity, the humiliation felt by someone who had to explain to colleagues and patients why she had been hauled out of her place of work in handcuffs, or the professional ripple effects, missed shifts, shaken trust among clients, and an emotional toll that, as the lawsuit would later detail, took months to heal. The ACLU intake came next. David Ramos, the attorney who took Vanessa's case, framed a federal civil rights lawsuit against the city and the officers, alleging what the record would characterize as constitutional violations: false arrest, unreasonable search and seizure, racial discrimination, and emotional distress. The legal theory rested on established principles: that police cannot detain a person without reasonable suspicion, that searches must be supported by law, that the Fourth Amendment shields professionals on the job the same as any other citizen, and that when officers overstep, there are civil remedies to vindicate those rights. Discovery would prove decisive. The single most important pieces of evidence in the civil suit were not a witness's memory or a written statement, but several reels of footage: the overhead feed from the pharmacy's CCTV and the body-worn camera mounted on Morrison's uniform. From those different vantage points, the story could be reconstructed moment by moment. Footage captured the cadence of the encounter: the initial request, Vanessa's measured replies, the physical steps the officer took across the counter, the way customers reacted, and the search of her bag. In the raw pixels of those videos were the facts that would later persuade a jury. Anyone watching the unedited footage sees something close to what jurors saw: a professional in her workspace, asserting the question of authority, and the officer asserting control without a stated legal basis. The footage had no interpretation written into it. What it had was context: timestamps, audio, and multiple camera angles, allowing observers to form conclusions about whether the officers had the requisite justification for what they did. Before the cameras, though, was a person. Vanessa's testimony at trial, when it ultimately came, would be anchored by the ordinary particulars of her life. She described the steady routines of her workday, the training she had undergone, the regulatory obligations that govern pharmacists, and the professional posture that made her steady in a crisis. She explained with quiet force the humiliation of being detained in front of customers and the long aftermath: anxiety, missed opportunities, and a sense that a fundamental protection had been disregarded. The officers' reports told a different story in shorthand: a call, an investigation, an enforcement action, clean, crisp, bureaucratic. The tension between those documents and the footage would become a central theme of the lawsuit. How often, civil rights litigation has shown, does an after-the-fact report attempt to recast an ambiguous situation as lawful? How often do initial police narratives precede a careful second look once video is introduced? Morrison was no first-time name in internal files. The complaint history and departmental records that counsel dug up showed that he had been the subject of prior complaints alleging aggressive conduct. Those records were not dispositive evidence of wrongdoing in this particular encounter. The law does not let us infer guilt or motive from a history of complaints alone. Yet in the hands of civil litigators, such background can be relevant to establishing a pattern, or showing that a particular officer's tactics were not isolated, but part of a broader pattern of behavior. The lawsuit pursued both the individual accountability of the officers involved and the municipal responsibility of the city that employed them. One of the defensive strategies mounted by the officers' counsel would be the invocation of qualified immunity, a legal doctrine that can shield government officials from civil liability if the law they are alleged to have violated was not clearly established at the time of the challenged conduct. At summary judgment hearings and at trial, the viability of qualified immunity hinges on whether an officer had fair warning that their conduct was unlawful based on then-existing precedent. The plaintiff's team knew this was a common but surmountable hurdle. The video evidence needed to show not just that the outcome was wrong, but that the officer's actions violated rights that were clearly established in similar circumstances. Expert testimony would play a key role in explaining these contours to a jury. A professor of constitutional law, whose name appears in the record with inconsistent spelling, appearing as both Chen and Chin, therefore marked indefinito in the case file, was called to unpack the Fourth Amendment standards in plain language, contextualize police practice, and explain what reasonable suspicion requires in a retail setting. Experts like this help jurors translate legal jargon into everyday intuition. Does the officer have a concrete, articulable reason for the detention, Or has he made an assumption based on a hunch or, as the complaint would later suggest, on racial profiling? The footage itself, and the way it was introduced in discovery, shaped the contours of the litigation strategy. Ramos and his team focused on preserving the unedited feeds, establishing exact timestamps, linking the camera perspectives, and preparing the narrative that would allow jurors to follow the sequence plainly. Preparing a case around video is different from preparing a case around witness memory. Video is merciless in a way that human recollection is not. It shows small gestures, the timing of words, the order of movement, and the proximity between people. It is not, however, self-explanatory. A jury still needs context, who is who in the frame, what the ordinary practices are at the pharmacy, and why a step across the counter matters in practical terms to a pharmacist doing their job. There was a second human thread that threaded through the files: the personal impact. Legal claims may track doctrine, but damages track lived consequence. The complaint itemized economic harms, lost shifts, lost clients and work interruptions, and non-economic harms, embarrassment, anxiety, and reputational injury. When an officer steps into your workspace and asserts authority without legal grounding, the consequences extend beyond the immediate indignity. For someone whose professional identity is bound up in public trust and precision, the blow can be existential. The city's initial posture was defensive. Municipal defendants often resist broad admissions of liability, and the public interest dimensions of such suits mean that both sides sometimes talk past one another in early press statements. But when prosecutors dismissed the criminal charges against Vanessa, the ladder of justification that had once supported the arrest, that an officer had probable cause or at least sufficient grounds to detain, went missing. The dismissal did not by itself determine civil liability. Criminal and civil standards are different. Dismissal of charges can be due to a variety of reasons unrelated to a civil finding. Yet to plaintiffs, it signals a significant moment where the state's own action, choosing not to pursue prosecution, underscores the weakness of the criminal case. As the pre-trial narrative developed, depositions painted vivid portraits. Witnesses included customers who had been in the store that day, pharmacy staff who described routine practices and the unusual nature of the officers' incursion, and the officers themselves, who offered their perspective on the call they had received and their decision-making in real time. The cross-section of perspectives is precisely the kind of material that juries use to triangulate fact from assertion. Civil litigation, especially civil rights litigation, is as much about shaping story as it is about law. The plaintiff's narrative arc: a professional stopped at her place of work, asked for papers without justification, arrested, and later vindicated in court, needed to be conveyed as both a legal violation and a human injustice. The defense's counter-narrative, that officers were acting within the scope of a lawful investigatory stop, that the arrest was justified and properly recorded, was equally about convincing jurors to see the same frames differently. A key strategic decision in any case like this is whether to pursue early settlement or let a jury hear the full record. Settlement offers are often attractive to municipalities. The financial cost of litigation, the publicity, and the risk of punitive damages motivate negotiation. But settlement can also limit public scrutiny. Vanessa and her counsel chose a path that would bring the facts into an open courtroom, where cameras were not permitted, but where jurors could see the footage under oath, where experts could testify publicly about constitutional principles, and where a jury could weigh the credibility of each side. That choice committed the parties to a prolonged fight, one that would test the strength of the video evidence and the persuasive force of testimony. There are two ways to think about filmed evidence in modern civil rights suits. One is procedural. Footage proves or disproves discrete factual claims. The other is symbolic. The presence of video changes the institutional response and public awareness. In Vanessa's case, both dimensions mattered. The footage did more than show a troubling interaction. It created a record impossible to easily rewrite. It shifted the litigation's center from competing recollections to a visual, time-stamped account. As discovery closed and pre-trial motions began to take shape, The doctrine of qualified immunity loomed large. Defense counsel argued that Morrison had not violated clearly established law, and therefore could not be held personally liable. Plaintiffs responded by pointing to controlling precedent, earlier cases in the same jurisdiction and similar fact patterns, that, they argued, put the officer on notice that his conduct was unlawful. Here, the expert testimony would connect legal doctrine with the raw footage, whether the officer's actions met the legal test for reasonable suspicion or for probable cause, and whether any reasonable officer in his position would have known that stepping over the threshold into the pharmacist's workspace and detaining a professional absent articulable facts was unlawful. At the same time as legal disputes about doctrine unfolded, the human cost multiplied in ways that legal filings only partly capture. Vanessa's narrative in deposition and in private conversations revealed sleeplessness, a loss of confidence, and a wariness when interacting with law enforcement afterward. Her colleagues reported new anxieties at work, customers asking whether everything had been resolved, competitors raising uncomfortable questions. Reputation, once solid, had become an unstable thing to manage. Against that background, the city faced pressure to respond institutionally. Personnel decisions, internal reviews, and public statements all formed part of the aftermath. Morrison would eventually be fired, Brennan suspended and reassigned. Those administrative actions are part of the public record that would later factor into the narrative of accountability. The city also announced reforms, changes to training, review protocols, and the adoption of stricter documentation practices when officers detain private citizens. The reforms to civil rights advocates seemed overdue. To municipal lawyers, they were a necessary step to restore public trust. Whether reforms translate into reduced incidents of unconstitutional stops is an empirical question outside the scope of any single lawsuit. But in Vanessa's case, the reforms were presented as a direct institutional response to the litigation's pressure. What this story shares with other high-profile civil rights suits is the catalytic role of recorded evidence. In cases stretching from street stops to public institutions, video has increasingly made what was once contested into something visible and interrogable. When video is clear and context is provided, it becomes a lever. It clarifies timing, identifies inconsistencies, and allows juries, citizens acting as impartial fact-finders, to weigh competing narratives. For civil rights plaintiffs, video can transform a case from he said, she said, into here is what actually happened. Vanessa's decision to move forward publicly, to allow a jury to see the footage, to testify herself, and to put her life on display in service of constitutional principles, was not a neutral choice. It was a gamble that the truth, once seen, would speak for itself. It was also a strategic calculation that the remedy she sought was not merely financial recovery, but a public accounting and the chance to catalyze change. In the months after the arrest and the filing of the lawsuit, a small but persistent community coalesced around Vanessa. Former patients sent letters of support. Local civil rights organizations amplified the case. Colleagues testified to her competence and character. News outlets began to cover the story with a mix of legal analysis and human interest. That public attention, while uncomfortable at times, also became a resource in the litigation. It shaped the context in which jurors would later hear the case and the public narrative that would accompany judicial decisions. And still the legal wheels turned. Motions were filed and argued. Motions to suppress certain evidence. Motions challenging the legal sufficiency of the claims and the inevitable skirmishes over whether qualified immunity applied. Each motion required a careful translation of doctrine into the facts on the tape. Plaintiffs urged the court to view the facts through the lens of a clear constitutional baseline. You cannot detain someone without reasonable suspicion. You cannot search a personal bag without proper justification. You cannot ignore a professional's clear articulation of their status and training simply because of a hunch. Defendants countered with the claim that policing involves split-second decisions in ambiguous contexts, and that the law affords officers some leeway in those moments. There is a reason these disputes are best resolved under oath and in front of jurors. Jurors are asked to weigh credibility, to determine whether a professional's testimony aligns with the footage, and to decide whether a public officer exceeded the legal bounds of authority. In Vanessa's case, the footage made the juror's job more straightforward than in many other disputes. Yet even clear footage requires narrative framing. Who is the viewer to trust? How does the law apply to the facts? And what remedy is appropriate when constitutional lines are crossed? As pretrial deadlines approached, both sides engaged in a flurry of preparation that is visible to anyone who has watched a courtroom drama. Expert reports, mock examinations, and careful choreography of which clips to show. Plaintiffs aim to show the encounter intact and in sequence. Defendants hope to contextualize the same footage with dispatch logs, witness statements, and a theory of policing that emphasized officer discretion. The difference between the two approaches would, in many ways, determine how a jury understood the same visual information. By the time the case was set for trial, it had transcended the particulars of a single arrest. It had become a test of accountability in a city whose department was under scrutiny. It had become a raw example in debates about racial profiling and selective enforcement, particularly in retail spaces where professionals of color have reported being treated differently, despite clear, lawful credentials. It had become a story about the power of evidence and about whether civil remedies can serve both individual redress and broader institutional reform. Yet none of the actors in the room, not Vanessa herself, not her attorneys, not the prosecutors, could foresee with certainty what a jury would do with the footage. Would jurors see the officer's actions as an understandable, if unfortunate, attempt at policing? Or would they see a constitutional violation demanding accountability and, perhaps, damages sufficient to send a firm message? The question loomed and the tension built toward a courtroom test that would be as much moral as legal. As discovery closed and trial preparations shifted into full gear, the community that had rallied around Vanessa watched closely. Advocates for civil liberties circulated timelines of the encounter. Local business owners debated the implications for storefront interactions. Vanessa, who had once been defined publicly by the steady competence of a pharmacist behind a counter, found herself recast as an emblem of resistance to overreach. The lawsuit, filed against the city and the officers involved, sought more than money. It sought an admission that certain practices are unacceptable on constitutional grounds. The next stage of the story, the trial itself, the jury's deliberations, and the calculation of damages, would make headlines. But before that public reckoning could take place, there was a quieter, technical, and crucial phase. The meticulous sifting of every frame of video, every notation in an officer's report, every witness line of sight, and every piece of documentary evidence that could corroborate or undermine competing accounts. That phase is less glamorous than the spectacle of a verdict, but no less important. In modern civil rights work, it is often the discovery phase that determines whether a case is survivable in court. And as counsel prepared to bring the story to 12 jurors, the question at the center of the litigation remained deceptively simple, yet legally complex. When an officer asks for identification and moves to detain a professional inside their workplace, what factual threshold must be met to justify that detainment? In Vanessa's case, the plaintiffs argued that threshold was unmet and that the constitutional violation was clear. Defendants argued that the officer's discretion and perception created a reasonable enough basis for action. The answer would hinge on law, evidence, and the human capacity to weigh one version of the past against another. At stake, beyond the particulars of one arrest, was a public lesson about accountability and the ways in which recorded evidence can transform a claim into proof. For Vanessa, for her career, and for the community that watched, the unfolding litigation was a crucible, a place where private harm sought public remedy, and where institutional change could be nudged into being if the law and the facts aligned. As the pretrial calendar closed, the scene returned in memory and on screen to that fluorescent-lit counter, the bell above the door, and those 5 words that began the ordeal. "Let me see your papers right now." The words had set into motion months of legal maneuvering, community response, and the eventual civil action that promised both vindication and a reckoning. The evidence was gathered, the witnesses prepared, and the city and its council braced for the courtroom test that would determine whether a jury would translate the visual record into liability, and whether that liability would include not just compensatory damages, but an expression of punitive accountability. What happened next would rely on a jury's common judgment, the persuasive force of expert testimony, and the way the recorded moments spoke when placed under oath. The rest of the story, the trial arguments, the jury's weighing of damages, and the institutional responses that would follow, would unfold in open court, where citizens acting as jurors would be asked to make sense of an ordinary professional's encounter with police and decide whether that encounter violated basic constitutional protections. The courtroom was packed the morning the trial began, but the cameras that had once captured the arrest would not sit in that room. Instead, 12 jurors took their seats as the legal teams prepared to translate video and lived experience into law. What they would see and what they would hear was the careful work of lawyers turning pixels and papers into a story with consequences. Plaintiff's counsel opened with the tape. Not a highlight reel. Every clip in sequence with timestamps intact. The overhead feed from the pharmacy, the body-worn camera from Morrison, and a third angle from a hallway camera were played side by side so jurors could see context, angle, and timing together. The effect was immediate. You could watch the micro-gestures that had once seemed small but proved legally significant. The precise moment the officer crossed into the pharmacist's workspace, the distance between persons, the cadence of Vanessa's words as she asked, calmly, "Why? What am I suspected of?" The footage let jurors see that the interaction unfolded in front of customers, with the pharmacy's routine interrupted for no articulated reason. David Ramos structured the courtroom narrative around two straightforward propositions. First, that the Fourth Amendment sets a floor for citizen treatment, and that those limits were crossed. Second, that the harm to Vanessa was real and measurable. He walked jurors through the legal baseline in plain language. Reasonable suspicion, he explained, requires specific and articulable facts, more than a hunch but less than probable cause, pointing to criminal activity. Probable cause, a higher threshold, demands a fair probability of criminal activity or evidence. The tape, Ramos argued, showed none of the facts needed to meet those tests. The officers had an interaction. They lacked a legal foundation to detain and search a professional at her place of work. Defense counsel painted a different picture, urging jurors to view the footage through the lens of policing realities. Calls can come in with sparse information. Officers must make split-second assessments, and discretion matters. They urged deference to officer judgment and highlighted the procedural record, call logs, dispatcher notes, and the officer's contemporaneous reports to argue that the stop was an attempt, however imperfect, to investigate a possible complaint. The defense also pressed the doctrine of qualified immunity. Even if mistakes occurred, they argued, the law was not sufficiently clear to subject the officer to personal liability. To resolve those claims, the jury needed help translating doctrine into fact. The plaintiffs brought in a constitutional law professor, whose name in the record appears inconsistently, Chen Chin, and is therefore flagged indefinito, to explain the Fourth Amendment's application in retail and workplace contexts. The professor walked through precedent, showing jurors how courts have required officers to articulate specific facts before detaining someone. Using exemplars from the same federal circuit, the expert explained that a professional's role behind a counter, combined with documentary proof of lawful status, undercuts an officer's claim of reasonable suspicion, unless the officer can point to more than proximity or a vague tip. Ramos then called Vanessa to the stand. She testified plainly, with a voice that sometimes shook but never broke. She described the ordinary structure of her day, a cadence of prescriptions checked, a register of controlled substances managed, patients counseled, and how the officer's demand for identification broke that rhythm. She recounted the sensory details that the video captured, but that testimony made human. The hush that fell over customers, the metallic click of the handcuffs, the weight of questions from colleagues afterward. She explained the practical consequences, canceled shifts, baffled patients, and the slow erosion of confidence that followed being publicly humiliated at work. She detailed how the search of her purse produced documents that already should have resolved the encounter, the very credential that marks a pharmacist's legal authority and standing. Cross-examination aimed to chip away at perception and memory, to suggest ambiguity where the plaintiffs had presented order. But the footage remained. It did what footage often does. It controlled the sequence and timing in a way memory could not. Jurors repeatedly leaned forward at moments when the video showed a clear sequence of actions. Their focus was visible on faces when Vanessa described the aftermath. Testimony from co-workers, employees who had been in the store that day, corroborated routines and confirmed that the officer's incursion was atypical. The defense could point to a procedural record and an officer's stated belief, but it had to reconcile that record with the visual evidence. Under oath, Morrison explained his memory of the call, his perception of risk, and his decision-making in the moment. Brennan, the partner officer, whose demeanor in the narrative had been more hesitant, described the same events with differences in emphasis. Her deposition had suggested reluctance. In court, she testified to following protocol, but the footage again provided the most stable account for jurors to weigh. The qualified immunity argument narrowed the dispute into a two-step inquiry for jurors and for the judge. First, whether the officers had violated a constitutional right. Second, whether that right was clearly established in a way that would place a reasonable officer on notice. Plaintiffs' counsel tied the doctrinal question directly to the tape. They pointed to prior cases in the same federal circuit where courts had found that detaining a professional behind a counter without articulable facts violated the Fourth Amendment. Ramos argued those precedents made the unlawfulness of Morrison's actions reasonably clear. The officer did not have the protection of qualified immunity because jurisprudence already set out boundaries he had crossed. Jurors watched parts of the videotape multiple times. The prosecution of civil rights claims in federal court is painstakingly local in that regard. Judges and juries will compare conduct here to precedents in this district and circuit. Plaintiffs emphasized cases where similar behavior had yielded liability, while defense counsel highlighted distinctions, differences in facts, the presence or absence of corroborating reports, or the perceived danger at the time. The law professor helped jurors navigate those nuances, always returning to the practical question: could an officer point to specific facts that made the detention reasonable at that moment? If not, then constitutional limits had been violated. Beyond doctrine, the damages question required testimony from those who could speak substantively to loss. Without inventing new experts, the record contained documentation of missed work, canceled shifts, and communications from concerned employers and patients. Plaintiffs introduced contemporaneous records, schedules showing missed hours, client emails, and statements from colleagues that aggregated into an economic loss narrative. Non-economic harms were presented through Vanessa's testimony and corroborated by friends and colleagues who described her changed demeanor, anxiety, and loss of reputation. Counsel argued that those harms were not abstract. They were the measurable effects of a public, lawful professional being detained and searched at work. The trial moved into a pivotal phase. Jurors were asked to decide liability for constitutional violations, and if they found liability, whether punitive damages were appropriate. Plaintiffs framed punitive damages not merely as compensation, but as a societal statement, a way to punish conduct found to be willful or reckless and to deter similar behavior by others. Defense counsel countered that punitive awards are reserved for egregious conduct, and urged jurors to consider the context of policing in the moment. When closing arguments arrived, the courtroom felt taut. Ramos reminded jurors of the core images: Vanessa's composed question, the officer's demand, the step across the counter, the search that turned up the documents that should have ended the dispute. He urged jurors to see the case as more than a dispute between a professional and police. He asked them to weigh whether constitutional lines were respected. Defense counsel asked jurors to appreciate the difficulty of policing decisions and cautioned against replacing officer discretion with hindsight. The judge instructed the jurors carefully on the law, how to apply reasonable suspicion and probable cause, how to consider qualified immunity questions, and how to approach damages. Deliberations were earnest and lengthy. Jurors, a cross-section of the community, debated moments on the footage with the precision of lay fact-finders. Was the officer's behavior reasonable under the circumstances? Did the tape show artful compliance or an unnecessary escalation? Could the officer claim a good faith belief he was investigating a complaint? The jury's task was to weigh those questions under the legal standards the judge provided. The verdict, when it came, was decisive. The jury found for Dr. Vanessa Lynn Mitchell. They concluded that the officers had violated her Fourth Amendment rights, and that the actions amounted to false arrest and unreasonable search and seizure. Importantly, the jury rejected the shield of qualified immunity for the officer who crossed the counter. They determined that, in light of existing precedent and the facts as shown on the video, the right implicated had been clearly established. The damages phase followed. Jurors awarded $8.4 million in compensatory damages and $7.5 million in punitive damages, for a total of $15.9 million. The compensatory award reflected both economic losses, documented missed shifts, reputational harm, and lost opportunities, and non-economic harms, humiliation, anxiety, and the ongoing effects of trauma in the workplace. The punitive portion was a statement meant to punish the misconduct and to deter similar conduct from officers or municipalities in the future. In their deliberations, jurors made clear they considered not only Vanessa's personal injuries, but the institutional message such a verdict would send. Courtroom reaction was immediate and profound. Vanessa's counsel allowed the moment to be human. She wept quietly, not in triumph, but in relief. Colleagues embraced. Community advocates stood outside the courthouse in muted celebration. The verdict was not only monetary. It was a public vindication that a jury, after seeing the tape and hearing testimony, concluded that constitutional limits had been breached. In the weeks that followed, the institutional consequences unfolded. Administrative action had already begun during litigation. Morrison was fired. Brennan received suspension and reassignment. The city announced changes, revisions to training emphasizing documentation and de-escalation, new protocols for detaining individuals in workplaces, and improved auditing of internal complaints. Municipal lawyers emphasized that reforms were intended to restore public confidence. Activists insisted reforms needed independent oversight and continued pressure to ensure practice matched policy. Vanessa's path after the verdict took a turn from private recovery to public advocacy. Recognizing the broader lesson her case might teach, she helped establish a Fourth Amendment defense fund aimed at supporting professionals and community members facing similar encounters, and at promoting training for both police and communities about constitutional rights. She took invitations to speak at conferences and panels, sometimes flanked by civil rights organizations, offering not legal advice but testimony about what it feels like to be on the receiving end of an unjust stop. The fund grew slowly, but became a platform. Donors who cared about constitutional protections, local business owners who worried about similar incidents, and lawyers who saw the need for resources to assist clients in documenting encounters. The case also fed conversations in law schools and police academies. Legal scholars debated the jury's award and the practical implications for qualified immunity doctrine within the district. Police training officers reviewed the footage as part of revised curricula, using it to demonstrate the legal boundaries officers must respect. Civil rights groups used the verdict as a teaching moment. The power of recorded evidence combined with deliberate litigation could compel accountability. National media picked up the story, and Vanessa became a face for a broader debate over race, professional identity, and policing. Interviews emphasized the image of a pharmacist in a white coat, someone whose professional station might normally insulate them from suspicion. Being treated as if papers, not credentials, were the threshold of respect. The narrative forced uncomfortable questions about how professionals of color experience public spaces, and how, in some cases, credentials are disregarded when race triggers suspicion. There were critiques, too. Some argued that the verdict would chill policing by punishing officers who make honest mistakes. Municipal lawyers fretted about the fiscal implications of punitive awards on local budgets. Reform advocates cautioned against assuming any single verdict would change systemic practices overnight. Vanessa herself, mindful of the complexity of public discourse, emphasized neither victory nor vindictiveness. She framed the outcome as accountability, an important boundary reasserted by a jury that had seen the evidence. The city's announcements of reform were followed by measurable, if incremental actions, new documentation requirements for stops and detentions, mandatory refresher training on constitutional limits for officers, and a promise of civilian oversight in reviewing future complaints. Whether those measures would produce long-term cultural change in the department remained an open question. Litigation can prod institutions, but sustained change often requires continued oversight, community engagement, and political will. For Vanessa, the verdict closed one chapter and opened another. Financially, the award provided resources to rebuild and to support the defense fund she helped create. Psychologically, the jury's vindication did not erase the memory of being handcuffed, but it confirmed that a community of citizens had weighed the facts and concluded the state had overreached. Professionally, colleagues and patients expressed renewed support. Some clients who had wavered returned. Yet the scars of public humiliation do not vanish with a verdict. Vanessa continued to speak about the quiet aftermath, the worry when an emergency siren wailed, the brief moment of flinch when a uniform appeared, the ongoing work of restoring a sense of safety. The case also rippled into municipal practice. Police unions pushed back against what they described as a punitive award that could hamper officers' willingness to act. Department leaders insisted reforms were intended to support lawful, effective policing while respecting civil liberties. Local legislators held hearings where the evidence was discussed, not to relitigate the jury's decision, but to consider policy responses focused on training, transparency, and complaint procedures. Members of the legal community watched the case for its implications on qualified immunity doctrine within the circuit. The jury's rejection of qualified immunity in this fact pattern signaled how compelling visual evidence can alter the calculus of liability. If officers cannot point to clear, controlling precedent that justifies stepping across a workplace barrier and detaining a professional without articulable facts, then qualified immunity will not shield them. The practical result for municipal risk management was simple: clear training, precise documentation, and an emphasis on de-escalation are not just good practices. They reduce exposure to liability. Community organizations used the case to push for broader reforms, better body-worn camera policies, easier public access to footage that documents stops, and independent review of complaint investigations. The argument was twofold. Video evidence is misconduct when it occurs, and independent review helps ensure patterns are identified and remedied before they metastasize into broader distrust. There were also quieter victories. Pharmacy associations began incorporating conversations about interactions with law enforcement into continuing education. Best practices for documenting encounters, notifying supervisors, and preserving evidence. Small businesses that operate in public-facing roles took note. The idea that a professional's identity can be diminished by an unjustified demand for papers resonated across storefronts and counters. Throughout this long arc, the essence of the story remained personal. The way constitutional rights protect the ordinary rhythms of work and life, and how their violation exacts both immediate and lingering costs. Jurors, after viewing the footage and hearing testimony, had concluded that Vanessa's rights were violated, and that the harm merited substantial redress. That redress was not merely a payout. It was a public statement about the boundaries of lawful authority, and the remedy available when those boundaries are breached. In the months after the verdict, Vanessa focused on two priorities: rebuilding a private life after public ordeal, and using her experience to inform practical reforms. She testified at trainings, declined offers that sought to turn her story into spectacle, and used the defense fund to support others in similar situations. She declined to call for punitive measures beyond the law. Instead, she emphasized the legal and civic importance of accountability. the practical utility of recording encounters, and the need for mutual respect in public interactions. What this case underscores is not only the power of video as evidence, but also the complicated interplay between law, institutions, and everyday human dignity. For jurors, the experience of weighing pixel by pixel was an exercise in civic responsibility. For Vanessa, it was an effort to reclaim the ordinary dignity of a professional's work. For the community, the verdict offered both satisfaction and a reminder that constitutional protections require vigilance and enforcement to mean anything in daily life. The story closes where it began, at a counter under bright lights with a professional asserting her rights. The difference now is that 12 citizens, after watching the tape and listening to testimony, translated that assertion into a legal judgment, a recognition that constitutional limits matter, and that when they are crossed, there are remedies. The $15.9 million verdict, divided into $8.4 million compensatory and $7.5 million punitive damages, stands as the numerical summation of that judgment. Accountability rarely arrives in a single, neat package. Policies change slowly, cultures evolve gradually, and individual healing is seldom linear. But this case demonstrates how personal courage, meticulous documentation, and patient legal work can produce outcomes that matter both for the individual and for the community. It shows that recorded truth, when paired with legal process, can compel institutions to answer for their actions, and can, at least in part, restore what was taken from someone who was simply doing her job. If you want to learn more about Dr. Vanessa Lynn Mitchell's case, the Fourth Amendment protections at issue, or how to support organizations working on policing reform and civil rights litigation, you'll find links and resources in the description below. And if this story matters to you, consider watching our other investigations into police accountability and the role of video in modern justice.